Whoa, hold up. The judge just asked when the last time she used was. This isn't just a check-in. It's a high-stakes competency review. Think about it. If a person can't comprehend what's happening, the court legally can't move. Forward. Mental state matters. Big time.
If you were drug tested today, what would the results be? All right, when's the last time you used? And the thing is, just be honest with me, because I'm trying to give you conditions to help you. And so far, because you're not currently on probation, what you're telling me is not a violation of your probation.
Hear me, yo, watching how them
Miss Silva? Yes. How are you doing today?
You're better.
Better?
Yeah.
Okay. So they told me you had seen a doctor, so what we're gonna do, because I wanna make sure the doctor says it is all right if we proceed with your case. So I'm gonna call you back in April, okay?
Mm-hmm.
Now, and it's gonna be April 29th, so that's a Tuesday. If your doctor says that we can see you before then we'll see you.
Notice how the judge isn't rushing anything? That's because due process trumps expediency. The court's making sure Ms. Silva is mentally fit before proceeding, meaning she must understand the charges and potential outcomes. This is the justice system hitting the brakes. Full fairness.
Before then. And so far what I have from the doctors that we're not supposed to see you just now because they want to make sure that you have all the right medications.
Okay.
All right, do you have any questions about anything?
No, so I'm still waiting to go to bench.
Yes, but if
Is there a way I can get out of it and get my own apartment and get my life together?
let me just tell you, you'll need to talk to your attorney about that. And then, well, we're going to make sure they come here. Miss Ferguson, who is her attorney is, all right, can you tell Mr. Pettis he's needed back here? All right, so we're going to make sure that you meet with your attorney today, all right?
Okay.
All right, thank you.
Is it possible I can have position? Or that's
Um,
what?
No, so the way the legal system works, if a doctor gives us a report and says that we can't go forward on your case, for whatever reason it may be, then we're not legally allowed to continue. So if they're saying that you're not on your right medications, that they need you on your right medications, then legally we're not able to go forward. And the reason why that is done is to make sure that you know everything that's going on and that you understand everything, that you understand what you're charged with, that you understand the consequences if you were to enter a plea. What I can tell you is the last time we were here, your attorney did enter plea paperwork, but then after questioning you, we thought it was best that you see a doctor to make sure that you understood the charges against you and the consequences of them. Now, what I can tell you is sometimes what will end up happening is before people are sent to SASH, it's determined that they're competent and that they can help in their case. So if for any reason...
Remember earlier when plea paperwork was entered? Well, plot twist. After further questioning, the court realized Ms. Silva may not have truly understood what she was agreeing to. That's why competency checks are crucial. A plea deal is only valid if entered knowingly and voluntarily.
And it's determined that you're currently competent, then what will end up happening is another doctor will have to see you and they'll have to say, yes, we believe she's competent. And then if your attorney and the state's attorney accept their findings, which normally they do, then you'll be brought back here. Okay. You're welcome. All right. So let me put this in the system.
Thank you, Honor.
You're welcome. Have a good one. All right. So Miss Silva.
Silva. Yeah, they're following my company now.
All right. So
This was the document that came.
yes. So I have this. So what we're doing is we're going to recall her case. And we're going to call it for April 29th. And here you go. And then if she regains her competency, from talking to her, because I was explaining things to her, she may be competent, I'm not sure. But once she's at the jail for a while, my understanding is she's waiting for transfer to the state hospital. So if you talk to her and you think she's regained competency, you can just ask for another competency evaluation.
Okay.
But we're going to bring her back on April 29th. And Miss Silva, it's not going to show up in the system that you're coming back on April 29th.
That gonna show up on the system?
It's not going to show up in the system. We know it, and we'll have you brought over. The reason why we don't put it in the system is if they come to pick you up for the state hospital and they see you have a court date scheduled with us, they're not going to take you. So just know that we know, and your attorney knows, and he's put it in his calendar, that you're to come back on April 29th, okay?
Okay.
All right, thank you so much.
Okay,
Yes.
I can't get on with police, or I can't,
No,
go to CPS or something?
No, you can't. I'm sorry. No, you can't.
Like, some kind of CPS person?
No, I'm not.
Quick insight for you court watchers. They're intentionally not putting her April 29th court date into the official system. Why? Because if the state hospital sees a scheduled court appearance, they might not proceed with her transfer. It's a tactical move, not a clerical error.
Not in charge of CPS, but what you'll have to do is you'll have to speak to your attorney if there's something else you want.
Okay.
Thank you.
Thank you. Rita Dela Cruz. And probation, this is an application. Court is calling 2024 CR 010009, State versus Rita Dela Cruz. Can I have parties announced for the record? State.
Case hearing. David McLean for the defense.
And are you Miss Dela Cruz? You're gonna have to make sure you speak up so everyone can hear. Are you Miss Dela Cruz?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Dela Cruz, did you review the application for deferred adjudication or community supervision with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Count 2, proceeding on count 1 alone. No objection, Judge.
Ms. Dela Cruz, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand in count 1 you're charged with tampering or fabricating physical evidence with intent to impair as a third-degree felony?
All right, new face on the docket. Miss Rita Dela Cruz. Different case, different stakes. This one's all about tampering with evidence, a third-degree felony. You might be thinking, how serious is that? Well, try 2 to 10 years serious.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Dela Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 1 and they're recommending deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have any such motions?
There have none.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your Honor, review that from my client, we have no objection.
All right, state you may be excused. Did you review the waiver with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor, we waive PSI.
All right, anything you wish to say on behalf of your client?
Your Honor, I've spoken with Ms. De La Cruz about this. She's wearing a mask today. She just got done with pneumonia and some pretty severe bronchitis. My main concern placing her on deferred adjudication in this case was the fact that we were talking about methamphetamine in this case, as the court's just reviewed. I've talked with her about how addictive that is. She has assured me that she is going to seek the proper help. This latest health scare has really gotten her attention. I think she can be successful on this, and we'd ask the court to follow our plea bargain.
All right, so question, in the police report, it said that she had a warrant.
Deferred adjudication isn't a free pass. It's a legal second chance with strings attached. If she violates the terms, that deferred part disappears, and the court can impose the full sentence. Think of it as a legal tightrope walk. One misstep, and the consequences catch up fast.
For an attempted possession, is there an active open case in Bexar County? Was that out of Bexar County? All right, state. In the police report, it says that she had an active warrant for an attempted drug case. And at first I thought maybe it was the same one that's in the indictment, but now I'm not sure after reading through the rest of the police report. And she says it was here in Bexar County, so I don't know what has happened with that case.
I have no clue, Judge. I'd have to call my investigator to look that up.
Huh?
Just to just step back.
Yes, if you could look that up,
Okay, good.
just in case.
Thank you, Judge.
All right, if you'll just have a
It's
seat.
the same case too.
No problem. No problem. So if y'all can step up, and I'll step back, and I'll take that up after we discover about that.
Thank you.
You're welcome.
I think I have it, but
Okay.
it was out of this court, I believe,
Okay.
and I just can't confirm if it was that one or not, but it looks like it's the same one, and it's been resolved out of this court.
Okay, so it's been resolved?
Judge, from my perspective, I confer with my client about it. She said that it was a warrant for an MTR out of this court
Mhm.
that's actually been adjudicated and she was sentenced.
It was a possession of a gram that was reduced to an attempted, which to Class A, obviously, and then she had a warrant for it, and it looks like it's closed out on Odyssey.
Okay.
I did send it to my investigator to cut it down, but she doesn't have anything else pending in Odyssey in our county.
Okay. All right.
You
And then, you know what? I still have to.
Okay.
Attempted possession.
Yeah,
Yes.
that's what it says.
Cause for 1, 2, 2, 4, 5,
Yes.
4, 5, was a revocation.
All right.
It wasn't,
No,
and that's what it's listed as.
All right. Thank you. Thank you. All right, Miss De La Cruz, if you come forward, please. And we're back on the record in 2024 CR 010009. All right, Ms. De La Cruz, if you were drug tested today, what would the results be?
Clean.
All right, when's the last time you used? And the thing is, just be honest with me, because I'm trying to give you conditions to help you. And so far, because you're not currently on probation, what you're telling me is not a violation of your probation.
Well, I didn't use methamphetamine. I was using marijuana.
Okay.
It was about 2 weeks ago.
All right, so I can tell you, marijuana and bronchitis doesn't mix.
I haven't been using anymore.
So that's a problem. Do you have any children?
Yes, ma'am.
What are their ages?
My oldest just turned 16. No, he's about to be 17. My youngest just turned 11, and then my daughter is 14.
All right, and do they live with you?
Yes.
This is not good. You understand? And then why were you at the park after hours?
Because what happened was, me and my kids had went to the park for a short period of time, and when we got back home, my son realized he didn't have his phone on him, so we went back to go look for it, and that was I didn't realize the time that it was already close to 11:30, and the park closed at 11.
And see, Bashan, that goes back to what I said. Nothing good happens after 10.
This is true.
See, thank you. Thank you for agreeing with me on that. All right. This is what the court will do.
Forgive me, ma'am, for it's my the bronchitis and that it just gives me hard at breathing and stuff. They gave me an inhaler and everything, so forgive me if I'm not at my best.
No problem. I understand. So the court is going to sentence you to 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 8 months. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, I'll deduct 100 hours of the community service restitution. How far did you go in school?
I was a 3-year graduate. I graduated as a junior.
All right, so what are you planning on doing with the rest of your life?
Well, after high school, I actually went to medical school, and I was a medical assistant for a short period of time, and then I kind of lost track on that. So that's what I was hoping to go back to, but I can't now.
No, not while you're on probation. All right. There is going to be, if you enter into some type of trade school and obtain a certificate, then the court will subtract the remaining 100 hours of community service restitution. There's going to be 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So where did you get off track in your life? You're telling me you graduated early as a junior, so where did life take a left turn for you?
I think it was probably when I was pregnant with my daughter, that my OB prescribed me narcotics, and I didn't know how highly addictive they were. So that was my introduction to the drug world.
All right, so here's the thing. Your attorney will tell you that in this court, to be successful, communication is key. I want you to be clean and sober. I want you to be a good example for your children. You still can be a good example for your children. But if you don't communicate with us and if you don't try, there's nothing we can do for you. If there's an issue, let probation know. If you feel they're not addressing it, then you can come back to the court. If you think you're going to use drugs, pick up the phone and call probation. And I will tell you, when I was a defense attorney, sometimes you knew there were certain judges, do not call that phone and tell them you're thinking about using. But your attorney will tell you in this court, if you're thinking about using, the best thing you can do is pick up the phone and call your probation officer. And if you can't get in touch with them, if it's during business hours, the best thing you can do is come into this court and say, I'm thinking about using. And if you just want to sit in this court, because that can help you get through not using for the day, you're more than welcome. We're here. We'll let you sit.
Yes,
You understand?
thank you very much.
All right. Good luck to you, okay?
Thank you.
Thank you. Thank you.
We'll see you.
You too. Have a good one.
You too.